any cause and effect studies, but at least it has an inventory. Now I'm going to leave you with the scary part. So, docks were banned in Blakey Harbor. And I have a client group that sued, saying that you violated our vested rights, you had an illegal shoreline moratorium, and I took that up to the state Supreme Court, and the state Supreme Court said the moratorium was illegal, which meant it violated my client's rights to vest their project. Vest means that if you file an application before the law changes, like the ban on private docks, you get to go under the old regulations. And we won the moratorium case, and we were awarded $73,000 in attorney's fees. So we sue in federal court, contending that you violated our federal civil rights because you imposed an illegal moratorium which damaged our clients. The city defends that by 3 propositions. You don't even have a property right to a dock. You don't have a. The second thing to defend is, well, we actually won the moratorium case. And the third one is you can only sue if there's any rational reason for the moratorium. You can't sue for money damages. The federal court said, Reynolds, you and your clients are right. There is a property right to apply for a dock. And number 2, you did win the moratorium case. The rolling moratorium was struck down. The court struggled back and forth with the draft order, gave us, in fairness to the court, our day in court, we argued for 3 hours. He finally concluded that we weren't entitled to damages under the Federal Civil Rights Act because, at least on paper, the moratoriums were intended to try to protect salmon somehow. And what he missed there is that there's 2 parts to a moratorium. It's not just the purpose of the law, but the means. And he forgot that the means were already declared invalid because these rolling moratorium has stayed on for years at a time for no reason. The state Supreme Court struck that down as being unreasonable. So the next thing is, okay, if we can't sue for money damages in the Federal Civil Rights Act, we'll sue them for a taking because the city defended the dock ban on the basis they needed an aquatic park. Blakey Harbor was pristine and we shouldn't have docks there. And the classic definition of a regulatory taking is forcing somebody like you to donate your land for a public benefit like a park. The city is defending that motion on the basis of 2 propositions. And I really wonder if the city council knows these arguments are being made for them. The city council's position is you have no property rights to your shoreline. Not just your second-class tidelands, but your uplands. That the state can regulate your uses down to banning them completely because when you bought your land, you didn't realize that it was subject to the public trust. And so government actually has that trust or ability to regulate your land. And therefore, if a ban development or use of your land, they don't have to compensate you for it. The second one, they're saying that for non-conforming uses, they can abate those uses without compensation. That's his present position, and I don't think the federal court's going to take up the issue because I think he's going to push those issues back to state court, which they probably should be. But I get Ken a copy of the brief and let him read it and see if he reads it the same way I do and post it on your site. So we're starting in the Shoreline Master Program process with the attorneys hired by the city telling you folks you have no property rights. Not only can they ban uses on the shorelines and uplands, but if your uses are non-conforming, they can abate those without compensation. In one little footnote, they can see, well, maybe we can allow you some useful life of your home or your dock or your bulkhead, whatever that means. So even though I've told you the law gives you balance and rights, the courts have been on your side in a lot of these issues, we're on Bainbridge Island. And the brief they filed in this case is extreme as anything I've read in 38 years of practice. And I've been all the way up to the U.S. Supreme Court with cases. I've argued cases in virtually every county in the state, Eastern Western District, the Ninth Circuit, and the U.S. Supreme Court. I've never read anything like this. And I suspect that the city council doesn't have a clue that these arguments are being made on his behalf. Maybe they do. Be interesting to find out.